Thank you very much, Ritas, and very special thanks to the State Chancellery in Latvia for welcoming us into their facility, into their capital. It's a beautiful capital, and I hope today I'll have a bit of time to take a stroll to really soak in the Baltic vibes. I'd also like to thank Baltic Institute of Corporate Governance for co-organizing this together with us and the State Chancellery. A very important event, as Ritas mentioned. We're here to launch the regional launch of the SOE guidelines, and I'm really excited to say that the Lithuanian translation is nearly on the way. The Latvian translation is, I understand, planned and will be on the way. So we hope to be able to also share the local translations of these guidelines with you very soon. So I'm going to give you some facts and figures about the guidelines so you better understand what's changed, because the guidelines have been around for the last 20 years, and they're the globally recognized standard. And we have recently revised them. So they were developed, we're almost going to celebrate the 20 years of the SOE guidelines. They were revised in 2015, and again, this year, they were revised to take into account some important changes, globally in the corporate governance environment, but also in the role and size of SOEs. Now, who oversees the guidelines? So it's an OECD instrument, and what that means is that the OECD Council adopts them as a legal instrument of the OECD, and they are adhered to naturally by all OECD member countries, but they can be adhered to by any other country. In fact, we have 42 adherents today, and this legal instrument is really recognized today as the global standard. There's no other standard dealing with the corporate governance of SOEs globally. And really, we have countries all around the world who look towards OECD members, especially those who have gone through recent reforms, corporate governance reforms, to better understand how they can utilize this instrument, which is purposely set at a very high level of aspiration, which is also designed in a way to what we call outcomes-based instrument. It means that no country may have the same path, but that the recommendations in the guidelines should lead to desired outcomes. So this is particularly relevant, I think, in the area of state-owned enterprise reform, because no country's path or reason to own SOEs may look the same. Sure, you may have some shared, maybe regional history or regional approaches, but really every country is unique in the way in why it owns SOEs, but also in the way it organizes the ownership and the governance of SOEs. And so they are designed to be flexible, and they're designed to also be proportional. So the idea is that, as many corporate governance codes also take into account the flexibility and proportionality principles, they're aimed to be adapted towards the size of the SOE, their commercial orientation, and so on. And they're purposely set at a very high level of aspiration. And that has been important because they're really seen as a lodestar for reform. We say no one country has fully implemented the SOE guidelines, but we do want to keep the bar high, and we see that has a lot of value when it comes to reforming SOEs. And we've heard all the good arguments shared by the Prime Minister, by the State Chancellor, and by also Ritas on what are the benefits of reform, and indeed managing SOEs responsibly, accountably, with integrity, with good corporate governance is key to economic competitiveness, in today's world, to economic resilience. I think the conversation has changed a lot in the last 20 years about the role of SOEs. I think we can all recognize that. And also towards sustainable development, and we see increasingly the need where there's a role for SOEs to play there. We also monitor the implementation of the guidelines, and we have recently just launched this report that looks at implementation across 59 jurisdictions. So if you want to get a sense of trends, I'll present some of them to you today, but I encourage you to go online, download our report, get a sense of how countries are actually implementing the guidelines in practice. Now, why are the guidelines important in today's context? what we see is that there is a growing role of SOEs in the global marketplace. We heard the figures in the Baltics. My guess is that the share of SOEs in the Baltics has probably gone down in the last 20 years, but globally, the share of SOEs has actually grown in the last 20 years. So we see this, the share of SOEs among the top 500 companies by revenue has quadrupled, which is quite significant. So just to compare and contrast with the Baltic figures and the international figures, we're really talking about the top 500 here. So we're talking about a sliver of SOEs, but the biggest, let's say, most globally significant ones. There are 126 out of the top 500. They employ 21 million people. They own 53.5 trillion US dollars in assets, and they generate 12 trillion US dollars in revenue. And a lot of these SOEs, a great majority of them, are not listed. And this has significance for corporate governance, because we know that listing SOEs can help drive better corporate governance, can help drive better performance. And many of these SOEs, as you can see from the chart on the left, operate in sectors that are quite significant, not only for economic resilience, but also sustainability. And you can see a lot of these sectors are actually greenhouse gas and capital intensive sectors like mining, petroleum refining, oil production, and so on. And these SOEs also drive the share of revenue, so they're actually quite important. So what's happening in global capital markets? We also see that SOEs are also important there. 12% of global capital market capitalization has the public sector as an owner. So what does this represent? It represents 12 trillion US dollars of global market capitalization, where the state is a significant owner. But this looks really different across markets, so I don't have the Baltic specific figures. Maybe some of you do, but I can tell you in Europe, for example, we see an average of 8%. In other jurisdictions, nearly 50%. So, and the OECD average is 2%. So that's why revising the guidelines has come at an important time, because we see these global changes. We see that SOEs are playing a key role, and we need to take that into consideration. And we have had 20 years now of implementing the guidelines, and we are able to take in that shared experience of implementing them across OECD members and other countries that have also maybe not adhered to them, but using them as a reference for reform to revise some key provisions. And I'll walk you through the 4 key priorities you see here listed on the slide. We did this revision process. It took about almost 18 months, involved all OECD member countries, so we have had all the Baltic states very much involved in that process, very much contributing. Also stakeholders in the Baltics, and in fact there are some colleagues here in the room today that participated to the public consultation process as commenting and sharing their views. So we've had quite an inclusive and transparent revision process. And that's what led to their adoption earlier this year, as I mentioned. So 4 key priorities. The first is that we recognize that SOE governance brings unique challenges. Why? It's because the intersection between the public sector and the private sector. So naturally, you have some challenges that you have to work around. And in particular, the corporate governance is really aimed to address principal agent problem, but in corporate governance of SOE, the principal agent problem is perhaps even more complicated, because you have the state acting in various capacity as owner, shareholder, then regulator, policymaker. So this can make decision-making challenging, right? And so the guidelines aim to strengthen recommendations that aim to separate these roles to ensure that the state acts as an informed and active owner. Secondly, you saw the figures on the growing share of SOEs. The issue of competition, fair competition, level playing field is becoming increasingly important. So we've looked at those provisions. We've looked also at the importance of setting high disclosure standards for SOEs. I mean, these were already in the guidelines before, but we've certainly strengthened provisions in those areas to ensure SOEs remain transparent and accountable, of course, when you implement the guidelines. And that boards also have the necessary competencies, integrity, and objectivity to carry out their functions. And as I mentioned, given the concentration of SOEs in sectors that are important for the low-carbon transition, we've actually added a whole new chapter dealing with sustainability and responsible business conduct, and I'll go into each of these in detail. First, to address the governance challenges of state ownership, again, as I mentioned, the guidelines really emphasize the state needs to act as a professional owner, an active owner, an informed owner. In practice, what does that mean? It means that the state should have a very clear idea why it owns SOEs in the first place, and that may change over time. It should have clear expectation for the SOEs, and many SOEs also fulfill important public policy objectives, sometimes public service obligations. So it's important to make all these things very clear for the state to have these ideas clearly, let's say, articulated. And what we see is there's also important to professionalize the way the state acts as an owner. And here we've seen a move towards the establishment of centralized ownership departments or agencies that really bring together important, let's say, civil servants or even mix of private sector experts under one umbrella to look after the SOE portfolio. So in Lithuania, we see there's a coordinated model. I believe in Latvia as well. And in Estonia, we have a department in the Ministry of Finance. So all different countries, again, as I mentioned, do it different ways. We have very different shades of gray. But in all countries, it's important to sort of group these important roles that the state owner can play under one, let's say, umbrella, and to separate this out from policy making and regulation. And what we see here is a move in over half of jurisdictions that we've surveyed have moved towards more centralization, more coordination, and also have established some sort of document or legal framework or policy that sets out why the state owns SOEs and how it seeks to let's say, govern them. And we see in the Baltic states, actually, in all of these areas, including on annual reporting on the performance of the SOE portfolio, that all the Baltic states are actually implementing all these good practices. So that's really reassuring. So what have we done to revise the guidelines in this area? Again, further emphasizing the role and functioning of centralized or coordinated ownership entities. What we see in the international landscape is also a rise in state holding companies. So we also had some provisions there. But I think the key message in the guidelines is really, how do you ensure whole of government approach? However you organize it in your respective countries, how do you ensure whole of government approach that ensures consistency and professionalism? We further worked on definitions of ownership and control in the guidelines. So you'll see that the guidelines have an applicability and definitions section, and these provisions now better look at how the state may still exercise control, even if it may not have, let's say, a corresponding amount of voting rights, but that still may exercise decisive influence in the decision-making of the company. And the guidelines would then, of course, apply. And also through corporate groups, right? And how does good governance look like in a corporate group structure where the state may be the parent, the owner of the parent company, but then how does that look like from a governance perspective vis-a-vis subsidiaries? So a few other areas, but in the interest of time, I will move forward on the second topic, which relates to how to ensure a level playing field when SOEs are out there in the market in potential or actual competition with the private sector. And there the guidelines emphasize this importance of separating regulatory and policy-making functions from the exercise of state ownership. That's also where the centralization of the ownership function plays an important role, because it helps you to sort of ring-fence that work from the policy-making or the regulatory work that other ministries or departments or agencies may be tasked with. Providing adequate redress mechanisms for stakeholders and competitors, and ensuring transparency around any public policy objectives and PSOs that SOEs may be assigned. And of course, adherence to general laws, tax codes, and regulations. So we see a mixed bag across countries. I mean, what we see is that in some countries, there's, even though SOEs may be subject to equal regulatory treatment as other firms, some SOEs may be prone to certain advantages, tax advantages, or implicit advantages, like because of state guarantees, being able to borrow at lower interest rate, which may tilt the playing field. And in companies that are fulfilling important public service obligations, well, of course, here in the region and all over Europe, you have state aid rules that apply that govern the importance of, let's say, adequate and fair compensation, but also require accounting separation where SOEs are carrying out public service obligations. So I guess in this part of the world, it's less of a problem, but there's still important need to ensure SOEs are compensated transparently, right? Because then the implicit advantage that can be derived from a compensation that is not adequate, let's say that is maybe overcompensated, versus the disadvantage it may cause for an SOE operating in the marketplace if it's undercompensated. So the guidelines call for provisions that really look at these aspects of compensation. They also discourage the use of SOEs to subsidize or grant advantages to other commercial undertakings, and encourage SOEs to act in accordance with commercial considerations if they're acting in the marketplace. And this is actually something that's come from trade agreements, because increasing number of trade agreements have disciplines on SOEs, and this topic of competitive neutrality is actually growing in relevance and importance even in trade and competition circles around the world. And we have actually had quite a bit of interest in the guidelines from people working on trade and competition. So it's important to be aware of these provisions and how they can reinforce also, let's say, obligations that trading partners have with each other. So on improving corporate governance, so the guidelines, of course, is an instrument dealing with core corporate governance issues just as much as they deal with the other issues. And here, the way the guidelines are designed are really promoting transparency and accountability. And how is this done? Well, one is through boards, ensuring boards are fit for purpose, and the other is ensuring SOEs act or are sort of operating in accordance with high standards of integrity, transparency, disclosure as well. So we've seen a lot of countries, and you'll be surprised, but we've seen a lot of progress in the last 20 years on SOEs being subject to the same or somewhat equal disclosure standards as listed companies. So over half of jurisdictions require this for their SOEs, subjecting SOEs to external independent audit, as opposed to just, for example, state audit procedures. And on the board side, we see that still there's work to be done. For example, on the issue of politicians sitting on boards, a quarter of countries still don't outright ban it. If they don't ban it, doesn't mean that maybe it's happening in practice, but still it's an important safeguard that could be worked into regulation or policy or even legislation in some jurisdictions. Here in the local context, we see that there's a ban, actually. And then on board independence, this is also important. Of course, this looks different across corporate governance codes, even in company law across jurisdictions, but we don't see a huge alignment with the updated definition of independence that we've added in the SOE guidelines. Now, new recommendations, what are they addressing? They're addressing the importance of the board's responsibilities with regards to risk management and the oversight of internal, external audit and controls. We have strengthened provisions dealing with board diversity, autonomy, and independence. And as I mentioned, the definition of independence has been strengthened as well. And more clarifications have been provided on the duties and responsibility of boards in particular as well, taking into account stakeholder interests. And last but not least, as I mentioned, we have a new chapter on sustainability. And there, I've given you the facts and figures on sort of the large share of SOEs in high-emitting sectors. but also we have another interesting data point when we've looked at the highest globally emitting companies that are listed. 18% of the shares of these companies have the public sector as an owner. So, you know, the state as an owner or SOEs themselves, who may be investors, are exposed increasingly to climate change related risks through these participation in these high emitting companies. And we see a very small share of countries, only a quarter, integrating climate related expectations into their ownership policies. And finally, when we look at greenhouse gas emissions and disclosure of them, of course, this is one aspect of sustainability. We recognize sustainability encapsulates a broader number of issues, also important social issues as well. More work can be done in terms of raising the bar on the disclosure of emissions, especially Scope 3. We have about roughly half of companies that we've looked at that are disclosing Scope 1 and 2. And so there we've mirrored also the G20 OECD corporate governance principles that have a whole new chapter dealing on sustainability, because this is equally important for all types of companies, not just SOEs. But the difference here is what we're saying, SOEs can also, or the state, can have an expectation that their SOEs can lead by example. So through setting clear expectations, through the ownership policy, through requirements or expectations on sustainability-related disclosures. And here in Europe, we have CSRD. In any case, that will be coming into effect very soon, so I'm sure it's something that will be important for SOEs and all other companies. For the boards to really be thinking about the opportunities and challenges that come with regards to sustainability. And finally, on responsible business conduct, in recognizing the role that SOEs have, their responsibilities towards their stakeholders and their employees. So this sort of wraps it up, but well, wraps up 2 years of work, I should say, actually involving all of you as stakeholders to that process. And I really look forward to the discussion, because it's one thing to talk about the theory, it's another to talk about in practice. So I look forward to further discussions the rest of this morning.
Thank you, Sara. Thank you, Sara. I think that we got more than we expected, because we expected to learn about what's new in the revised guidelines, but we got some analysis of our countries, how our countries are standing in one or different kind of areas. That is great. And let's try to see how our Slido tool is working. And I would like to ask my colleague Eric to start with the questions to Sara.
Yes, with pleasure. Question number 1. As SOE's presence in global business landscape is increasing, what is OECD's standpoint regarding changes in rationales when it is allowed for states to do business?
Thank you for the very good question. The SOE guidelines, and so my position, of course, is based on the consensus of our members, right, is that we don't question why a state should own SOEs or not. But if you do own them, you need to make it clear why you own them. Indeed, we do see a growing share of SOEs in the global marketplace. I mean, this also may be driven by developments in non-OECD economies as well, where we see the state-owned sector playing a more prominent role in these economies, and these large multinationals, which happen to also be state-owned, are more present in the global marketplace. So this is sort of driving the numbers the way you see it. So we don't take a position on that, but what we do say is that if they're acting in the marketplace, they should act in accordance with commercial considerations. They should also not, let's say, act in a way that can undermine global competition, especially when they integrate into global value chains or even operate in third markets. It's really important to uphold those high standards of conduct also, and ensure that when the state is sort of acting as a shareholder of the company, it's acting as a shareholder really what any shareholder would expect, right? A proper return from the company. And those kinds of provisions are integrated in the Chapter 3 of the guidelines, where you can look at, get further detail on what those expectations set out.
Thank you. Do we have time for one more?
Yes, please.
Next question is, what countries would you say set the best standard for implementing the good corporate governance guidelines in practice? And the aim of the question is, who should we learn from?
That's also a very good question. We don't like to pick favorites, and I think in every country there's something to take away, right, from the reform. And I said that every country has a unique path, and that guidelines are outcome-based, so there's no one way of achieving the provisions that are in the guidelines. But I'd say that in Europe, we have many good examples of corporate governance, depending on also the tradition, civil law tradition, common law tradition. All these things will impact the way the laws are developed, the way the corporate governance codes are developed, the way the tradition, corporate governance tradition. So I think in the region, you also have to look towards countries that may have similar systems as yours to be able to find inspiration. In Europe, though, we do have, from the Nordics and the Scandinavians, I think really, let's say, strong tradition of state ownership, but also strong tradition of the professional, the state acting as a professional owner, integrating very high standards, but also we see in, for example, UK, Ireland, some very interesting developments, especially, for example, on sustainability, some very interesting takeaways. But again, it'll look different. Some countries organize their ownership model in the form of a state holding company. So then company law applies to how those holdings are run, and they may have an independent board, may be sheltered more from political influence or undue influence. It's a tricky question, but we have to look at every national context and what are the challenges in every national context, design a framework that works there, because what may work in one jurisdiction may not be easily transposed in another.
Very diplomatic, but Scandinavia was mentioned, yes? Okay, last one. What areas and aspects of revised OECD SOE guidelines are most challenging in practical implementation? What do you think?
Good question. I think, the next panel we have will be focused on boards. I think on the board issue, this comes up all the time. Professionalizing boards, board composition, board remuneration. How can we hold boards accountable, right? When the state is an owner, how can it make its expectations clear? And sometimes maybe the boards are not doing the job, or maybe the state's not clear about what it wants the boards to achieve. And so these types of conversations between boards, the dialogue between the board and the shareholder, the state as a shareholder, is really important. And I think what makes corporate governance of SOEs more complicated is the intersection between public policy and business. Because the moment you mix those two, you get all sorts of politics mixed in, but also different goals and objectives. So that's why it's important to calibrate, right, expectations. So I was actually really pleased to hear that there's going to be annual expectations letter now in Latvia, as was mentioned by the Prime Minister. I think that's one good way of helping solve that problem, at least getting very clear expectations to the boards on what you expect of the state shareholder. Then board does its job, great. Doesn't, then you have means to deal with that.
Thank you.
Thank you, Eric, and thank you, Sara. And just to add that these expectations of the owner should not change every month.
That's true.
Thank you, Sara.